If you own assets directly in your personal name, it can create structural issues. You may hold shares in operating companies, investment portfolios, or real estate, but there is no central holding layer above them. On paper, everything looks organized, but legal ownership remains fragmented. This creates a practical issue such as slower succession, unclear governance, and banks often asking for personal guarantees because there is no structured ownership vehicle. If owner dies, control of these assets may need to pass through probate before decisions can be made. This is why families introduce a holding structure above their assets. A holding layer centralizes ownership, improves governance, and separates assets from personal estate. One way to create holding layer is through special purpose vehicle or SPV in ADGM, that is the Abu Dhabi Global Market. It allows you to introduce a regulated holding company above your assets and create a clearer governance framework. My name is Shiraz Wahid and I'm the co-founder at Lepidus Wealth, and in this video I'm going to explain how to set up an ADGM SPV step by step, what the process looks like, how long it takes, what documents are required, and how to structure it correctly from the start so it works for banking, succession planning, and cross-border asset holding. An ADGM SPV is a private incorporated company inside Abu Dhabi Global Market, which is a financial free zone operating under its own legal framework based on English common law. The SPV is typically used as a holding vehicle rather than operating business. In practice, this means that SPV does not usually hire staff, trade actively, or generate operational revenue. Instead, it holds shares in companies, owns investment portfolios, hold real estate, or act as parent entity above operating structures. This separation is important. Your operating business continues running as usual, but ownership sits above it inside the SPV. This creates a centralized ownership layer without interfering with the day-to-day operations. Families use ADGM SPVs to hold shares in a Dubai mainland or a free zone company or offshore companies, as well as international brokerage portfolio or cross-border real estate. Entrepreneurs also use them during acquisitions, joint ventures, or when bringing in investors. An ADGM SPV is primarily a holding structure. It centralizes ownership, separate assets from your personal name, and create a clearer governance framework. Tax treatment still depends on your residency, the location of underlying assets, and how income flows through the structure. Once this role is clear, the setup process becomes easier to understand. When setting up the SPV, the first step is not incorporation. The first step is defining what SPV will hold and why it is being created. This determines how the structure should be designed. For example, an SPV holding operating companies may require different governance compared to an SPV holding passive investments. A structure designed for succession planning may require shareholder layering, while a joint venture SPV may require different voting rights. This is also where control is decided. You can be the shareholder directly, or SPV can be owned by a foundation, trust, or another holding entity. That decision affects succession planning, asset protection, and long-term continuity. Banks often ask for this clarity during onboarding. If the purpose is not defined properly, the structure may still be incorporated, but banking becomes difficult. Once the purpose is defined, you then decide how the ownership of the SPV should be structured. An ADGM SPV requires at least one shareholder and one director. These can be the same person, or they can be different individuals or entities. The shareholder controls ownership while the director controls management. Separating these roles can create governance flexibility, particularly for family structures. For example, a foundation may hold shares while you remain the director. This allows you to maintain operational control while separating ownership from personal estate. Alternatively, multiple shareholders can be introduced for joint ventures or co-investment structures. Voting rights can also be customized at this stage. The decisions made here affect succession, control transfer, and banking perception. ADGM allows flexibility, but the flexibility should be used deliberately. Once shareholders and directors are defined, the legal details of the SPV are prepared. Now, at this stage, the company name is reserved and the legal form is selected. Most SPVs in ADGM are incorporated as private companies limited by shares. You will also define share capital. ADGM does not require high share capital for SPVs, but the structure should reflect intended ownership. For example, different share classes can be created if needed. The registered address is also assigned. Now, ADGM service providers offer registered office solutions for SPVs, which means that you do not need to have a physical office lease. This is one of the reasons SPVs are efficient for holding structures. During this step, the articles of association are prepared. This document defines governance, director powers, shareholder rights, and transfer rules. Once these legal details are finalized, the application moves to the next stage of documentation. ADGM requires identification and due diligence documents for shareholders and directors. This usually includes passport copies, proof of address, and professional background information. If shareholders are corporate entities, additional documents are required. These may include certificates of incorporation, registers of directors, and ownership charts. The regulator reviews the information as part of compliance checks. This is standard for regulated jurisdictions and supports banking credibility later. It is also important that ownership charts are clear. If multiple layers exist, they must be presented logically. Complex structures are allowed, but they must be transparent. After document submission, ADGM reviews the application. The timeline depends on complexity, but SPVs are typically incorporated within a few weeks once documents are completed. During this stage, the regulator may ask clarification questions. These are usually related to purpose, ownership, or source of funds, and clear answers here helps avoid delays. Once approved, the SPV is officially incorporated, and you will receive the certificate of incorporation, commercial license, and constitutional documents. At this point, the company legally exists, but it is not yet operational for asset holding or banking. The next stage focuses on making the SPV usable in practice. After incorporation, the register of shareholders and directors is issued. Board resolutions are prepared and initial governance documents are signed. This is when ownership transfer can begin. Shares in operating companies can be moved to SPVs, investment portfolios can be retitled, and holding relationships can be formalized. The timing of these transfers matter. In some jurisdictions, transferring assets may have tax or legal implications. Coordination with expert advisors in relevant countries is important. The SPV itself does not remove those rules. It provides the ownership framework, but underlying jurisdictions still apply their own laws. Once assets are ready to be transferred, banking becomes the next practical step. An SPV can hold assets without a bank account, but in practice, banking is often required, for example, for dividends, investment flows, or acquisition funding may pass through the SPV. Banks review SPVs based on ownership clarity, purpose, and expected activity. This is why earlier steps matter. A clearly structured SPV typically faces fewer onboarding questions from banks. Now, some banks may prefer SPVs owned by foundation or holding companies, while others accept individual ownership. The bank may request business plans, ownership charts, and asset details. And this is standard and should be anticipated. Once the bank account is opened, the SPV becomes fully operational. Once operational, the SPV acts as the central holding entity. Investments can be made through SPV, subsidiaries can sit beneath it, and ownership can be consolidated. This simplifies governance, so instead of transferring multiple assets individually, control can be managed at SPV level. This is particularly useful for succession planning. For example, ownership of SPV can later be transferred to a foundation or a trust without changing underlying assets. This avoids operational disruption. It also improves continuity. Directors can change, shareholders can change, but the assets remain held inside the same structure. The SPV therefore becomes a structural layer rather than an investment itself. In straightforward cases, the full process from planning to operational use typically takes a few weeks. Complex ownership layering may extend this timeline. It is also important to understand that an SPV is not a standalone solution. It works best when coordinated with wills, foundations, trust, and cross-border tax planning. When used correctly, it creates clarity of ownership, improves governance, and simplifies long-term control. So if you want our help and would like to explore whether these structures fits your situation, you can request a personalized asset protection plan by clicking the link in the description below. That's it for today, and I will see you in the next video.